All good. Now, where am I and why do I not see myself? I want to see me. Hello. There I am. My hat is, there we go. And take that silly thing out and make sure that my phone ringer is off. And we are good, I believe. I do believe. Right. And here we go. Okay. All right. And I need my coffee. On. All right. Coffee is coming. We can't have a talk without coffee. Quick break, and then close my door tight. I'm going to be busy for the next hour. Zoom.
What's up?
All righty, folks. From Blue Magma, I can't hear anything. Okay, Blue Magma employee. Other guys,
I could see.
can anybody hear me?
Matt, you might need to mute someone or mute
I'm going to
people.
go ahead and mute everyone, and if you need to talk, unmute yourself. I want to see, how do I do that again? Mute everyone, participants.
So you confirm you guys.
Participants.
Well, I looked in the shop everywhere.
And then there's a mute all. There we go. Mute all.
Talk to him, just see if you
Mute
know.
all. Okay, everybody is muted except me. If you have something to say to interrupt me, as always, go right ahead, unmute yourself, interrupt me, and then mute again. Let's see.
Luke, go.
I don't know what that was. Okay, 1 second, please. Okay. As always, come to my office, grab some mugs. We're actually running out of these new purple ones. I got to order some more because these seem to be the most popular mug we've had so far. Anyway, what I'd really like to do is get a bunch of these Yeti mugs, but these are like crazy expensive. And I think Rhonda's on here. Rhonda's company was kind enough to get me this mug. This keeps it hot literally all week, but very expensive and heavy as hell. Anywho, all right. Enough with the mugs. We are going to look at the agenda for today. Here, give me a moment. Here we go. So, my agenda. We're going to start with a review. Now, I apologize. I told everybody last meeting, which I think was 3 weeks ago, that Sunday, a mere 2 days later, I would have the language to put in the leases regarding how to deal with this new world order regarding this jury verdict from here in St. Louis County. The lawyers were with Spencer Fain. The plaintiff was the Bauman group, I believe it's called, Bauman something. And the facts on that case really seem to be extremely bad for the landlord. To remind you, or if folks are new, have not heard about this case, did not come to my last meeting. Basically, somebody was evicted, and there's something on the chat. Let me make sure I got the chat window open as well. Carla is here. Hello, Carla. And I hope, Blue Magma, can you type in if you can hear everything now? Because I think it might just be your volume was low, because everybody's hearing me. And in any case, okay, well, other people are hearing me. So either Blue Magma has no speakers or volume is down or other technical issues. We'll blame Zoom. I think Zoom is owned by China, so blame China. Anyway, this is what happens. Somebody gets evicted. The sheriff comes, their stuff is not only tossed in the dumpster, but also they had taken some stuff home. Employees had taken some of her stuff. Who knows? What was seemed to be reported by the St. Louis Post-Dispatch was that that they had pilfered her stuff before the sheriff even came, and they wouldn't let her in before the sheriff came. Somehow she got locked out before. I'm not quite sure, but also after the sheriff, they wouldn't give her any sort of an accommodation. Now, I've always been of the mind, you do not let them back in the door. If they missed the sheriff, it's too late, because if you let them back in the door, you could end up with a situation where they're like, I moved back in, you gave me a key, I'm back. Okay? No, it doesn't work that way. And I still maintain that, but with some caution, because we have to be more cautious based upon a jury verdict of, I believe it was $83,000 of real damages and another 80,000 or something of punitive damages. But the facts of the case seem to indicate that the landlord was truly terrible. Their employees just came and took her stuff, and it was bad. But we included on this week's email language, the underlying language pursuant to section 535.040 under a court-ordered execution for possession of the premises. Neither the landlord nor his or her successors, assigns, agents, representatives, blah, 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 shall be liable to any tenant in any way, shape, or form for loss or damage of any household goods, furnishings, fixtures, or any other personal property left in or at the dwelling by the tenant. I think vehicles should be added in there. By the tenant or subtenant of such dwelling by the reason of the landlord's removal or disposal of the property, except for willful, wanton, or malicious acts or omissions. It is the duty of the tenant to notify the landlord of tenant's intentions to make arrangements to recover tenant's possessions. And there's no, and that's fine. This will do some sort of protection. That phrase, the willful, wanton, or malicious acts, it seems to be that even with such language in the lease, it seems to me that the landlord in that lawsuit might have, or its employees or agents might have committed such willful, wanton, or malicious acts, if we're believing the reporting of the journalist who's been around a long time. I think he's, as journalists go, he's a reasonably good one. It's Tony Messenger. I think I've spoken to him once a year and a half ago. He was doing a story about COVID. I know I spoke with him, and he does seem to be solid. I don't know if any of you out there know the guy. I mean, I believe he's not a terrible, I think he's a real journalist, which are in short supply these days. Anyway, I think as a quick review, I think adding this language into your leases is important, okay? Now, moving along, you should still, if they have not gotten their stuff out by the time the sheriff comes, okay, try to make contact with them. You know, what are you going to do about your stuff? But you still should not allow them in without signing. I can provide you with a contract, and I'll explain it at the time. If they have an apartment or a house full of stuff, don't just give them the key. You send people to watch them move out their stuff. And I maintain even now that it is appropriate to charge for that. They had every opportunity to vacate before the sheriff. That woman came in here today, and I said to her, I said, I'm sorry, nobody, she came much earlier. I'm the only one in the building. All my employees are here now, but I was the only one here. And I said, hey, I have no time. I can't even talk. I apologize, but I'm in the middle of a phone call and I got stuff to do. And I cannot talk with you, but if you come back in a couple of hours, people might be here. She's like, but the sheriffs are coming. I was like, but I didn't know about it. Really, I wasn't going to engage because I didn't have time. Because I'm sorry, you got to go. It's polite. But of course they know. They get served or posted with a lawsuit. Every single one of them who tells you they never got it is a liar. They lie. Now, posting, it is possible it can fly off the building. They are also mailed. If it's posted, it is mailed. Posting and mailing always come together. So they get either served or they get posted and mailed. Then they miss court. And then there's a default judgment. Okay. Or they came to court and there was a consent. So of course they know about it. But if there's a default judgment, the court clerks in every single case mail it the same day. That's one of those things you can count on the court clerks doing. They mail it. And that gives them 10 days from that judgment date to file something with the court. But at least, even if they're not going to file anything, it gives them notice. They know about it. And what that says is you got to be gone. You got 10 days to go. Also 10 days to file something, but 10 days to go. Okay, I got 10 days to go. I'm going to ignore it. I'm going to put my head in the sand, stick my butt in the air, and pretend to be an ostrich. That's not going to work out well for you. Because the next step is we file a writ, and I'll get to sheriffs, by the way. There is very good news on sheriffs. You will not see it till next week, but all the problems seem to be fixed. So the next step is the sheriff's writ gets filed. Within a day or two, the sheriffs are putting it on their calendar and sending deputies out for the first of 2 visits. Because whenever we have a sheriff execution, there are 2 visits. They come and post the door, which the law does not even obligate them to do this. This is something that all the sheriffs in every county I've ever dealt with seem to do, but it's not a requirement of the Missouri statutes. But all the sheriffs go out approximately 1 week before the date that they are going to be there on the doorstep. And they say, we are going to be there on the doorstep, get your shit and go. Otherwise, you're going to be locked out. Okay, she missed the service or posting. She missed court. She missed the default judgment coming in her mail. She missed the sheriff's posting, and now the sheriff is on her doorstep. Where is the reality in here? There is none, but now we have stuff into place. So call me if that occurs. We'll work on a contract. If you want to let them in, you really should have them sign a contract. And frankly, you could have them pay in advance to do this, but within reason, maybe allow it to be at a very minimal fee. I mean, you can, this is not, you get your stuff back if you give us the money you owe us. This is, you want us to now go out of our way. We have to assign a couple of guys to watch you and bring the key because we're not giving you permission. This contract also says, I am not being given possession of the premises. I am not being allowed in as a tenant. I am being allowed in for the limited purpose only of retrieving my personal goods. So whether there's money exchanged or not, they have to sign this before you let them in through the door after the sheriff has come. Because if you let them back in after the sheriff comes, just generally, hey, you know what? You can stay an extra week. If the sheriff is come and gone, that case is over. You got to file a whole new case. All right. Now, that's that. I wanted to touch upon that briefly and let's move on. Generally, let's give the quick update. Then we're going to get to the emotional support animals. The quick update. Number one, I always go through is the courts and the sheriffs. Okay. And it's pretty much good news everywhere. Courts are working great. We've been working great in the city forever. We continue to work great there. We have a new judge as of 1 January. He's a very good judge. I will tell you that unlike most of the judges, I have now seen him twice allow defendants who have not previously filed a counterclaim basically do an oral counterclaim right at the time of the trial. And in trials, it's not terrible outcomes, but he doesn't award as much as we should get. He listens to their problems, even if they haven't filed a counterclaim or affirmative defense, and he seems to give them a little credit for whatever problems there were. At the end of the day, you're going to get your possession back and you're going to get a smaller dollar judgment, but most of these judgments being uncollectible, it's not a big deal. I don't think, and I'm not making light of you not getting a judgment for every dollar you are due, but it is what it is. It's the judge's prerogative. And in general, he's a good judge. He knows what he's doing. He's been around for a while. They rotate all around in these counties, but in the city especially, every year we get a new one. And Judge Reuter's been there before. He's going to be there again, but we've got him for 2023. Should have him for the full year unless he gets promoted to the circuit level, which is possible. He's a good judge. In any case, moving right along, St. Louis County, we remain in two different divisions. Our Wednesday judge remains Judge Payton. Everything's fine with Judge Payton, except that she limits the amount of cases we go in there with. So there are only 4 or 5 clients. What is it I've got in there, which is, what is it? Oh, it's St. Louis Leasing, Mills Bennington Heights, Timberland the Finn, and those 2 apartment complexes are very large and tend to have a lot of cases, and BLT or Real Vest. So those 4 clients of mine, some might be on here, those 4 clients of mine are in Judge Payton. Everybody else is in my Thursday docket. So for those who are with Judge Payton, everything's generally smooth, except she runs her courtroom kind of slowly. She is tough to get quick trial dates, but she's a good judge. She is a fair judge. I have not yet been truly disappointed in any sort of a ruling, but the timing thing is tough. One of the ones we sent to Nick for an emergency, Nick is also bulk docketed within Judge Payton's courtroom. It was on March 8th, she set it for trial. February 8th, last week, she set a matter for trial on an emergency case for late March. It seems to be totally insane, but it's judge's prerogative. Nothing we could do about these things. Moving along to my Thursday docket. Last year, we had Judge Julian working fabulously. Large dockets, everything moving smoothly. Thursday is all mine in that division. I got the whole day, basically. We have very large dockets and we're able to clear all our cases expeditiously. That's the most important thing for you guys, is that you file your cases and you're in court in what is a normal time frame. Now, there is massive volume coming in, not just me, but all the eviction attorneys are getting much bigger volume. Why? Because rental assistance ended. You all know that. Probably you know it because you're sending me more cases. But that might push things a bit. The other issue with our Thursday docket, and then we had Judge Julian, was great. We switched on 1 January to Judge Zellweger. Same story as Judge Julian. Everything's great. She has made a couple of times, if somebody takes the trouble to come in and make a motion to stay in execution, she's going to kind of give them a little extra time. It's only been 3 or 4 cases. But where no matter how strenuously I argue that the letter of the law is thus and so, and they are wrong, and rental assistance doesn't matter, my client's not participating, or whatever it may be, she still gives them extra time. There's nothing we can do about that. You know, judges don't want to put a family out in the cold, and that's how they see it. And if they can give an extra couple of weeks, they will. But ultimately, she's making the right decisions on trials. She's and she's pushing our cases through, and things are smooth. But very soon after we got her as the judge on 1 January, in early February, she got promoted to circuit judge. So since she is now going to be a circuit judge, we lose her in late March, and we don't know who we'll have because the impaneling of the judicial candidates hasn't even happened yet. So there's going to be a new judge. We don't know who it is. We might have a substitute judge for a couple of weeks where they cover, but that is what it is. The additional challenge in that Thursday docket is that in the month of March rather, because we generally have 2 or even 3 dates each month, usually 3. So in the month of March, we have March 2nd, then next week, the week after, and the week after that, no dockets. So our docket after March 2nd is March 31st. Is that right? Wait. Yeah, March 30th, rather. I think March 30th, March 31st. So it's 3 weeks later. 4 weeks later. So we missed 3 weeks with no dockets. That's terrible. That happens once in a while. But then right after, it is March 30th. Right after March 30th, we missed 2 weeks. And then we have the 20th and 27th of April. It'll all kind of even out after that. So our cases are being pushed through expeditiously. There is going to be a flood of cases. There are going to be backups for everybody. There's nothing we can do about it. Sheriffs are moving smoothly. As of now, we had in the county, they have completely reshifted everything. And since actually about a couple of weeks ago, Sheriff Kiefer took everything over personally. And right now it's working very smoothly. He and our office made a little bit of changes, which so far seems to be working well. We've got all the backlog and some things that were missed by the prior team, or somehow things got missed. Combination of our office and the sheriff's office. I don't know what happened. There's no blame laid anywhere, but there was some stuff was lagging in the county. It's all fixed. Moving on to the city, everything is going to be much, much better. 2 days ago or 3 days ago, it was Wednesday. So 2 days ago, Courtney and Zevi from our office met with Lieutenant Hogan. He is in charge of all evictions, and things will be excellent going forward. There's a backlog of cases that we didn't get the dates and times from them. It's been a mess. The mess is now fixed. Now, a note on some of these writs. In just the last week, we had I don't know, a half dozen or a few more cases come through where it's like a 2021 case asked with a judgment in late 21 or in the beginning of 2022 asking for a writ now. Don't do that. You can't ask for a writ on a case that's that old. First of all, in the city, if the judgment is 120 days old or older, we have to get the judge to sign off on it. Okay? As a general rule of thumb, if your judgment is more than 90 days old, maybe give me a call and question me whether, can we do a writ on this? Otherwise, something's wrong, okay? If a consent judgment contemplated a very long payment plan, then that's a possibility. But generally, that's not happening. This is something where things were slipped through the cracks. Maybe the prior property manager dropped the ball. You got a new employee who's trying to clear the deadwood and says, hey, we need a writ on this guy. But the judgment was last July. I had one that came in like that. You can't do that. You got to start a new case. Sorry. Moving right along. The other issue with writs of execution is going to be fixed by a portal fix, which I believe is already active. You are now, when you click on request writ, it should be giving you a little pop-up saying, are you sure you want to request the writ? We're going to be changing the language in there and actually giving a lot more detail. Why? Because sometimes you request a writ on Tuesday. On Wednesday, we file it, or even same day. But then the next Monday, you haven't heard yet from the sheriff, which still could be the case. So you're like, request writ. Now what you've done, not like laying it out all on you, but the way the system works, the way it was built, and we're working on making it better, but it makes it more complex, is the system doesn't know any better. Okay, request writ. It takes it out of filed writ status, and it's from that filed writ page where Zevi is tracking and making sure he gets dates and times. So if it's been removed from filed writ, it's gone. He's not tracking it. Why? Because it went back into request writ. Okay. And usually catches that when he sees, well, wait, we filed this 8 days ago, whatever. If you're going to go and file a writ, it's going to say, are you sure? What I'd ask you to do, just make sure you're not requesting the writ on the same one you just requested a short while ago. You can't just keep requesting the writ because we're going to keep it moving the status, etc. Okay. Soon, weeks, not minutes. It's going to say, you sure you want to request a writ? A writ was requested and filed. You know, it was requested on January 3rd. It was filed on January 4th. Today is January 11th. You sure you want to request it again? Or perhaps send a message for more info, something like that. Okay, that's what I'd like to see. That's going to be coming. Another problem with the portal has always been, you click on request dismissal in error, and then you let me know. Now it's like in there that there was a dismissal request. It's in the record. Okay. Hold on, Zevi, come in and grab it. Oh, sorry. Let me just give him. Here, Zevi. All right, sorry. There's another jurisdiction. Finally, is taking credit cards for Ritz in Jefferson County. So I decided to give them a credit card. Anyway, if you dismiss, then we make, then you, but it was an error. I always say immediately put a message, say, don't dismiss, I don't want to dismiss it. It was an error. But what's happening now, and it should be effective already as of yesterday, the day before, if you click request dismissal satisfaction, it should give you a pop-up, which is the final version of it. It should just say, are you sure you want to dismiss or satisfy this case? I actually want to change the language on that. I'm on the Zoom. What? I'm on Zoom. Oh, the link. Yes. Yeah. Sorry. Sorry, somebody needed the link for the Zoom. Copy invite link. Paste. Sorry. Okay. So, what was I saying? It's so if you request dismissal, it's going to pop up and it should say, are you sure you want to dismiss this? And by the way, if they've skipped but have not paid in full, click here. What that's going to tell us to do is dismiss it without prejudice. Okay, because we don't want to dismiss with prejudice, which is our default function. We default to dismissal with prejudice, which means everything's paid in full. Everything's fine. We're good. We can't file this case again for the months that we filed. Obviously, if next month they're late, that's a whole new deal. But a dismissal without prejudice says we've dismissed, but we have the opportunity to bring this case again. Or we have the opportunity to send it to collections and let them bring a future case. If we dismissed it with prejudice and you just said, hey, dismiss, and you're in your mind, you're saying they skipped, dismiss the case. No good. Okay. Now, incidentally, on all of these little tidbits, and today I don't have time to really go over other than to remind everybody, if you are acquiring properties or you're a property manager and you have owners that are acquiring properties, you need to remember there is an absolute, very strict rule. Before you're allowed to collect rent, you must notify them, and there's very strict rules. I've talked about it previously. If you're not sure, call me about it. Not today. Too many cases to file. Call me next week. Call me, even text me Sunday. Probably be able to talk Sunday. But here's the deal. You must comply with that. What I'm going to be doing, and what will be coming onto the portal soon, is that on every page of the portal, kind of along one side, are going to be instructional videos where the way I envision it is you're going to hover over it and it's going to pop up and give you a quick, what you want to learn about. There's going to be one section which is going to be the law and one section which is going to be the portal. So, how do I, what does the update ledger mean? How do I do that? Boom. You're just going to boom, and it's going to be a very quick one. And I'm going to be adding these things in. We're not there yet, but this issue of acquisition of properties must be complied with. I talk about it every time because it's so important, and every week at least I have an issue that pops up because nobody or most landlords don't know about this. And as I've said before, I blame real estate attorney bar for this. There's all these high-priced real estate attorneys who do jack all when they charge $400 an hour to do whatever it is they do. I don't know what they do. They're a waste of space. They charge very high dollars. And I'm talking about guys who are buying and selling one property for your, if you're doing a SFR company and you have a bunch of little landowners and it's a mom and pop buying one rental property, maybe they used a lawyer, maybe not. Even the title closers should know. But up to, it's an SFR company buying a package of 15 homes. They're using a law firm for that. What the hell is that law firm doing? I haven't got a clue because it's the title company that's checking title. Okay. They're What do? They collect the check and do nothing to protect the landlord. The third type is they're selling, everybody in town knows that Mills City View sold to my client up here on the group, Blue Magma. Both are clients, love them both. I got Mills, I got now Blue Magma. By the way, Blue Magma is a cool name. I don't know what Blue Magma is, but it's awesome name. But in any case, when that transfer happened, I'm curious. I think I warned everybody beforehand, make sure at closing, to do this. I guarantee you that the law firm that did that closing, which are probably big law firms, I won't name names because I don't know who it is, but there are big law firms, white shoe, skyscraper law firms, maybe even national or international law firms that do these things. And they don't warn them about this extremely important issue. Why? Because they don't know, they're incompetent and they're overpaid. In any case, moving right along. That is the story with that. But I will be putting on these various things on the thing, and of course, the ChaseNet portal demo. So, it's no longer you're going to have to click on a separate link. When you log on, there's going to be a link. And I would suggest that maybe when you log on the first time, it says, hey, you need a tutorial. I don't know if we do that, because then that maybe gets too complex. But everybody's big boys and girls, if you log on, tutorials right here. Okay. How do I file a new case? What do I do here, etc. By the way, with filing new cases, please, 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 please. Right before this, I was sending some into the court because I've got a stack this big. Everybody's case, I'm up to filing the stuff from the 15th now. There might be a few left from the 14th. So we're inside our 2-day window that we generally are. And that's what I'm going to do in the rest of the day after this meeting is done. But please, for the love of God, look at the size of your leases. If it is 7 meg or larger, please help me. And if you got to print it out because it's already on your computer, print it out and scan it at a smaller size, please do that, because it slows me down enormously if I got to start breaking that up into subparts to file it on CaseNet, because CaseNet cannot take a document of 7 meg or larger. It must be under 7 meg. It's not me, it's the court. Anyway, moving right along. Let me look at my topics here. We did the courts update. The sheriff delays have been fixed. Safer. Oh, let's touch upon Safer briefly. I spoke with Denise Poplar yesterday. She's one of these, she works with the St. Louis Mediation. I believe she's an advocate for, I don't know if she's so much an advocate for tenants as she is a mediator, but whatever. She's good people, and she has been working closely with Safer. We had heard a rumor, totally unsubstantiated, that 31 January termination of new applications they might be going back, reopening it. According to Ms. Poplar yesterday on the phone, nope, there is no such rumor coming from Safer that she has heard. Okay, she probably would have heard. I don't know if anybody knows anything further. Let's see. And I see there's a note on here from Cindy Slack. I was told to call a Patty Montgomery by another attorney. What is that referring to, Cindy? If you unmute yourself and hop on and let us know. So, but in any case, the rental assistance has ended. Now we are still seeing, maybe it's the last vestiges of this, the last struggles of a dying behemoth, but there are cases where we have rental assistance is coming, but the client wants to push it along. There's always, and I've said it before, there are two possibilities. If we look at a flow chart, the first box says, you want to continue a case, but there's rental assistance. Have you been participating in the rental assistance with the tenant? If yes, go here. If no, go here. So if the answer is yes, go here. We got to be real cautious about what we do. talk to me, call me, okay? If no, if you're not participating in the rental assistance, it's money coming from the tenant. Doesn't matter where it comes from. It could be coming from rental assistance. It could be coming from, him selling his neighbor's kidney, out of the bathroom with the ice in the bathtub, or it could be coming from his job. Doesn't matter where it comes from. It could be coming from his mom, borrowed. That's just money from the tenant. So you don't need to concern yourself that rental assistance is involved if the answer is A, no, I am not participating in rental assistance. But if the answer is B, I'm participating in rental assistance, call me for guidance. I'm not going to get into the permutations here, but proceed with caution. We only have to do this for a couple more months because it's over and we're just waiting on payment on some, and it seems to be that you could be waiting up to a couple of months. But a couple of months from 1/31 as the final date of an application is 3/31. So we're halfway there, more than it's 2/17. We're halfway there. From 1/31. So this is almost over. I hope and pray that we never hear the words rental assistance again, but who knows? These things have a way of not going away. I mean, if this actually goes away, this is going to be the first government program in history to disappear, because government programs never die. My understanding, and somebody could correct me if I'm wrong, there was I remember reading years ago that there was a subsidy for the manufacture of what's that really soft fur? Oh gosh. The name escapes me right now. But it's some sort of you have to grow the animals to manufacture this fur. And in I want to say the Spanish-American War, our soldiers needed it for their socks or their shirts or something because it was cold. And they subsidized the growing of this sort of whether it's a cloth or an animal skin, I don't even remember. That program still exists today. Why? Because government programs never die. So I'm going to lift up a cup to the government. If this actually dies and the rental assistance is over, that's going to be like a first in history. So, and somebody is texting me, my wife is texting me, mink or chinchilla. It is not mink or chinchilla, but it's something like that. Super soft. I don't know. But the government decided to subsidize it, and that's where we're at. It never goes away. But this program has gone away. Now, it is now 11:38, and we're going to get to emotional support animals. Now, I don't know if everybody saw this morning's. I know in the past, and I apologize as always for maybe I put in jokes which could be a little offensive. I put in jokes from like the movie Airplane, and Leslie Nielsen could be terribly offensive. This time, I don't think I offended anybody unless you're a dinosaur or a dinosaur owner. So I put in this the emotional support velociraptor link this morning because we were speaking about emotional support animals, and I've always said, and I gotta eat crow a little bit. Not really. I mean, there's just been some cases that have come down in recent years which are making this a gray area. It is no longer black and white. Let's wait a second. We can look at a flow chart again. Let's look at which law are we concerned about, Missouri law or American law? Problem is, we got to be concerned about both. But under Missouri law, there's no such thing as an emotional support animal. It doesn't exist, as I've always been saying. That is still correct under Missouri law. Okay, but on this flow chart, we got to go down. I love flow charts. We got to go down the other side, which is federal law, Fair Housing Act, all the fair housing rules. Emotional support is really a thing. Now, I'd like to go over a few kinds of permutations of this, and I would recommend talk to me about it. Okay, just in the last couple of weeks, spoke with David, I spoke with Yasmin about these things. In general, you can make a blanket policy if you want to just give in to the mob. You could say if somebody presents you with a certificate of ESA, then you don't charge them a pet fee. You allow the animal even if the building is no pets allowed. You could do that. Okay. I hate to suggest that you do that because as far as I'm concerned, you all know that the pets cause more damage. There is no way around it. Even the most well-behaved dog, cat, ferret, whatever, they're still going to cause more damage. The dogs, the best dogs on earth, if you got hardwood, are going to scratch it because they have nails, unless they wear slippers. I don't think they can. They're going to crap and pee in the house. Then again, I have a son that did that. We won't discuss that. He was 2, but he was marking his territory. But it damaged the house. It damaged the carpet. We weren't in a rental. It didn't matter. It's our own house. But dogs and cats cause damage. Okay, children cause damage. You know, relatives cause damage. That's why you all limit how many people are allowed in there, how long guests may stay, and whether or not you allow pets, whether or not you allow smoking. By the way, side note, if you don't allow smoking, that means you also don't allow weed. They still got to smoke outside. Now on this, it's simple. You don't want smoke. Your other tenants don't want smoke. They could challenge you on it, but I think you'll stand in a strong steading there. However, if you don't allow illegal substances and now everybody's smoking weed, well, too bad, so sad. It's now legal. Okay? Nothing you could do about it. So, some things with the pets. So, let's take the first case. So, here's the deal. The Fair Housing Act requires that a housing provider to allow a reasonable accommodation involving an assistance animal in situations that meet the following conditions. Now, before we look at the conditions, they call it an assistance animal, okay? And if you look at the language, the problem is that there are 2 types of animals, and this is what I've always preached. There are emotional support, and there are service animals. A service animal is an animal with a job. They're usually dogs. Service dog is a dog with a job. The dog is trained professionally to be a seeing eye dog for the blind. The dog is trained professionally by the military to sniff out bombs or explosives. The dog is trained to sniff out tunnels, I understand, in some countries. The dog is trained with epileptics or autistics. I've heard there are some sorts of specifically trained dogs that help epileptics or autistics. Fabulous. I guess with the epileptics, they might be able to tell a seizure is coming or the seizure happens and they're able to assist. I don't know enough about dogs, but that's what it is. Those are service animals. There is no doubt, and I'm sure all of you understand, there is no doubt that you must treat these dogs as service animals. There are no pet fees for a service animal. It's a no dog building. You allow the dog. The man's blind. He needs a seeing eye dog. Okay, you can't say to him, no dog, use your cane. It's not proper. Okay, and somebody, my wife again has texted me diabetics. Apparently, I guess they can tell if there's a diabetic shock coming on. Fabulous. You'll see more of this as they decide what they can do with dogs, and then when one of these companies gets a hold of the dogs and manipulates their genetics so that they're more intelligent than dogs and they're as smart as maybe a somewhat dim-witted person, and then they got even more. Then we're into different territory and everything goes bad, and then we're going to have our AI-driven phones are going to somehow get firearms, and then Skynet, and they're all going to kill us. And basically, it's the Terminator, and everything goes badly. But until then, the dogs are not human intelligence, but they still have lots of jobs, and all of those service animals, of course, you have to treat with respect. I have said forever, emotional support animals are not a thing in Missouri. It's still true, but under federal law, they do view this, but they have to tell you what it's for. But then again, you're not allowed to inquire too much. This is where you might just give up and say, this is just a thing, and we're just going to give up if somebody gives us a certificate, whatever. But let's go on. So, assistance animal in situations that meet the following conditions. The request was made to the housing provider, to the landlord, for a person with a disability. Everything with the Americans with Disabilities Act and Fair Housing relates to disability. Okay, so request was made to the housing provider for a person with a disability. Number two, the request was supported by reliable disability related information. You know, look, they lift up their sunglasses. You see they have no eyes. Here's my service animal. Everything's clear. But if they say, this is my emotional support poodle, I am disabled, I am weak without my emotional support poodle, then that's not necessarily reliable disability related information. But to what extent can you inquire? Hold on for that. And then the housing provider, the landlord, has not demonstrated that granting the request would impose an undue financial administrative burden on the housing provider. Okay, usually it does not. The fact that the dog and cat cause more damage than just humans living there is almost certain not to be proof of the imposition of undue financial or administrative burden. Okay. Secondly, that the request would fundamentally alter the essential nature of the housing provider's operation. Now, there's an example after where that actually shows that could be the case. Okay. Number three, the specific assistance animal in question wouldn't pose a direct threat. Okay. Direct threat to the health or safety. This is where I will go back to, and I know I'm going to get dinged by Courtney in my office, who has her lovely, peace-loving, beautiful, calm pit bulls. Pit bulls are bred for viciousness. And if a pit bull is listed as an emotional support animal, we've had this in the past, where the emotional support pit bull at one of our apartment communities out in Maryland Heights, the emotional support pit bull mauled a little, it was a toy poodle or something. It was a little tiny dog. And the emotional support, oh no, that one wasn't the mauling. This one was, it was trying to get at the toy poodle through the deck balusters, and it had chewed up the balusters. Okay, that's not even if it's an emotional support animal, even if they have a believable, provable emotional disability, that animal is vicious and dangerous, as evidenced by it trying to eat the deck to get at the toy poodle. That said, you can't have a blanket, no ESA of a certain breed. But there are situations, for example, many of the municipalities either completely ban certain breeds or they require proof of parentage of the dog in question. Okay, because they don't want dogs that are bred by some puppy mill that's training dogs to be guard dogs for used car lots. That's a different type of animal. Frankly, I even call that a service animal. If it's bred to be a guard dog, that's a dog with a job, but not the kind of dog you want in an apartment complex or even maybe a single family home. But the things might be very different with a single family home than apartment communities. Most of the times we have these problems with ESA animals. Very often it's in apartment communities where they have a no pet policy. Okay, we go from there. Also, I would argue, because we had one a couple of months ago where they said not only was it an emotional support animal, which maybe the landlord would have been willing, but there were something like 3, 4, maybe even 5 dogs in the place. You don't get to have 5 dogs or 3 dogs even if the pet policy is 1. So the pet policy is 1 pet. But you say, well, for my emotional support, I need my twin Rottweilers. But ma'am, you live in a studio apartment that's 400 square feet. And there are people with toy poodles next door. And you have twin Rottweilers that are each larger than you. Maybe that's an interesting, place to look at. So, in any case, that is potentially a problem. Let's look at some case laws. There was a policy. There was a policy that was allowed. There was people in the place that were living there knowing there were no pets allowed. And in fact, a tenant had a dog allergy. And this came to court. Now there's nothing in Missouri. Understand, there's no Missouri case law. So we're looking around the country. This happened in Iowa. So one of our neighbors, for the geographically challenged, to the north. So I can say that with a smile because I come from New York, where we all grew up kind of geographically challenged about everything in the middle. But I am happily done with the East Coast. Anyway, so what happened in Iowa? We had a tenant with severe allergies. She lived in the premises first, and the landlord made an accommodation for a new tenant who had an emotional support animal, but the court ruled, that it wasn't a reasonable accommodation because the tenant with the pet allergies had priority in time, and the dog's presence posed a direct threat to her health. And it doesn't have to be a life-threatening thing, but why should she have to live with sneezing all the time when she moved into the place first? Okay, and that kind of bears also on someone who comes in, signs the lease. We had this 2 or 3 weeks ago, maybe they sign the lease, and then the next day they sign the lease saying, I have no pets. Okay. And then the next day when they moved in, they said, oh, and they said, what's with the dog? Here's my emotional support certificate that they printed off online. These are case-by-case basis. So basically the entire thrust of this discussion about ESA is that it's always going to end up being on a case-by-case basis. Okay. So we will kind of get to that. In any case, the court ruled that that the holding was based on the specific facts of this case, and there's balancing in this case is not one size fits all. That's what that court said. Might not be the same result under different circumstances, such as when the animal at issue is a service animal for a visually disabled person. This is where rational judges and sane courts are going to always, of course, fall down. Where you're going to have problems is when irrational or frankly foolish judges are going to be like, well, we can't question somebody's emotional need for their 6 dogs, 1 cat, and a parakeet. You have to allow it in the 400 square foot unit. There's going to be cases like that. It is bound to happen. But as of now, no. Okay. The next case was dealing with aggressive dog behavior, which we discussed. Now, this case comes out of Vermont. If a landlord has a no pets policy, the tenant may be provided a reasonable accommodation for an assistance animal if they demonstrate that he's disabled. And that's one of those tests that from the beginning we said they have to demonstrate that they're disabled. Okay. So a certificate they print off from the internet that says, with a gold stamp, they print on their color printer, this is an emotional support animal certified. This pet went through the online certification process, and it's all clicked and all the right things that it's no. But if the landlord has no pets policy, they may be provided reasonable accommodation for assistance animal if the tenant demonstrates that he or she is disabled and that the tenant has a disability-related need for an assistance animal. Again, we're using the word assistance. If the tenant establishes these elements, the landlord must modify or provide an exception to the no pets policy to allow the tenant to use an assistance animal. And by the way, very often, this is not a way to get in a pet where there's a no pets policy. Usually it's a way to avoid the $25 a month or $50 a month dog fee by calling an emotional support dog. The trial court did not err in finding that the tenant was not entitled to a reasonable accommodation. So that double negative basically means that the landlord was right for this specific emotional support animal because there was evidence that the dog was aggressive. It showed aggressive tendencies, and some residents avoided it and others were afraid of it, and the tenant might not be able to control it. That's all fairly rational sounding, right? But everything here is on a case-by-case basis. Last case here, no, so there's 2 more. You need evidence of the tenant's need for the reasonable accommodation. This is where you got to be careful because you can't inquire too much. Oh, you have an emotional problem. Let's talk about your emotional problem. We don't believe you. You know, you tell, so you're just crazy. You know, obviously I'm being facetious, but that we can't go there. Okay. But how far can we go? Our policy says you have to provide us with a true medical professional's note that they've actually, you know, no, I don't want to know about your emotional problems. I don't want to know about your any mental issues. We're not asking about that. What we're asking for is a note from a real doctor, not an online, you know, generator of fake certificates. And you would say just like this: we need a note from a real doctor who's actually treated you, which says, in that real doctor's opinion, you have this need for this emotional support animal based upon your disability. That's it. We don't want to know what your disability is. We're not asking about it. That's your private business. Okay, but that's about as far as you want to inquire, and you want to be cautious about this. Okay, if you want to maintain such a policy. Absent evidence that any occupant was entitled to a reasonable housing accommodation based on disability under the federal statute, 42 USC, the trial court erred in relying on the spirit of federal law and granting equitable relief to a tenant. They're saying the trial court had said, well, you know, the federal law really wants to be super accommodating. And the appellate court, this case comes out of Connecticut. The appellate court there in Connecticut said, nah, the trial court was wrong. And in granting the equitable relief to the tenant in a summary process action based on the emotional benefits of keeping a dog in violation of the lease. That's basically striking at the heart of the whole concept of emotional support. You know, yeah, it could be good. It could be good, but it's not necessarily 100%. And then the last case coming out of Indiana. You need some evidence identifying disability or symptoms. Tenant asked the landlord if she could have an emotional support animal and provided a letter from a licensed family and marriage therapist, which said that the tenant had a disability and needed an emotional support animal to help alleviate her symptoms. The letter, however, identified no disability or symptoms. The landlord requested more information from the tenant. When the tenant did not provide requested information, brought the animal into her apartment, the landlord evicted her. So I'd be cautious there. Even though the landlord successfully evicted her, I'd be cautious because you don't want to inquire too deeply. Okay, so in these sorts of situations, call me and we will discuss. And then that is basically it. So now, having covered that, and I want to make sure I did some, let me just click on, I've got to click on something here that is time limited.
Matt, you have questions
Yes, I
coming up.
know. I'm aware. Okay, so okay, so sorry, I've got too many windows that tend to be open at once, and there we go. So, all right. So I would like to open up the floor for questions from the gallery. Notice I didn't say Peter Gallery. Sorry. Please unmute yourself if you're asking questions. Oh, wait, somebody, we already have a question on the thing. Are residents limited to one service animal for vision impairment, hearing, etc.? I would say, yeah. I mean, I would say at this point, and that's user 5, whose mom really was not kind in naming him or her. But user 5, here's the answer. I would say, has anybody, and this is what I would say in a court of law, has anybody ever seen a blind person with a pair of seeing eye dogs? I don't think so.
Matthew, there could be more than one person living in the property
Sure,
that is blind.
Of course, Courtney. So that's 100%. That's 100%. So what the heck? Oh, something started that shouldn't have. Sorry. All right. So second question. So of course, if there's more than one resident, each resident can have a service animal. Now, if it starts to be, you have 4 people, you allow 1 pet in the residence, and each person needs their emotional support dog. Again, case by case, I'd really start inquiring that every single person in this house has a medical condition that needs this. But seeing eye dog for sure, but I'm talking about 1 person. I think that's what the question was geared towards. Of course, if there's more than 1. Any other questions?
Hi, Matt. I have a question. I just want to clarify. So are you recommending that anytime we evict a tenant and they want to come back and get their belongings, that we allow that with that signed document? Or are you saying it's up to us as landlords, or what are you recommending?
Wait, you just went silent. Hold on, you just went silent. Hello. Hello?
Hello?
Oh, you went silent. I don't know if everybody else, I lost you for a bit.
I was just asking if you are recommending that we always work with evicted tenants to allow them to get their stuff, even though, you know, we have multiple communications telling them the sheriff is coming, you
Oh,
need to be
I
out.
think it's a case by case basis. Going back
Okay.
to that first topic, it is for sure a case by case basis. And I think here the facts of the Bauman property case will bear upon this. The facts of the Bauman property case were really ugly, according to Tony Messenger's reporting. They were really, and it seems we looked into it a little further. I have not tried to find the transcripts of this trial. Unfortunately, I don't have time for that. But the facts as reported were terrible. They were pilfering stuff before the sheriff even got there. Okay. And they were particularly nasty to the woman. So being reasonable is good. But if you have a clear paper trail that you remind them, then the sheriff's coming and the sheriff came and we're getting the dumpster on Tuesday. You got the weekend. You're going to be fine. I'm sorry, no court, I don't think, is gonna find against you in that, because how far are you supposed to go? What we don't want to have happen is the sorry, I'm losing my train of thought. We don't want to have it where the situation that they have in, for example, a state like New York. My understanding in New York, before they call it marshals there, before the marshal can even be requested by the lawyer, the landlord is required to pay and show proof to the court. That was told to me. So if I'm wrong, I'm talking about a friend named Howard who does some landlord stuff on Long Island, Nassau County, Long Island, and Suffolk County. The landlord must show the court that they have prepaid a moving and storage company that's licensed, bonded, and insured, okay? To move all their items carefully out of the house into storage, prepaid for, if I recall, 6 months. That's required before you're allowed to evict them. My feeling on that is that's insane obligation of a landlord. And when somebody's kicked out, if they lose all their stuff, too bad, so sad. On the flip side, when you are trashing out a house, I've said this individually, I've said it on these Zooms, I will say it again. When you're trashing out a house, if you come across what is clearly, a couple of family photo albums, important keepsakes, their passport, jewelry, box it up. It'll be probably one, file box worth. Box it up, stick it in your office in a safe spot that's not going to get flooded out, because that's just the kind thing to do, even if they're terrible people, even if they were kicked out in a horrible situation. They leave their kids' stuff all the time. They leave their medicines put the medicines in there, because 3 weeks after it, they're gonna come to me like, I need my diabetes medicine, I ran out. Don't worry, here's your box of stuff, and make them sign for it. Important stuff from the trash out of this. And I would even on that receipt, I'd say, I agree that I have no claim of anything for anything else, make them sign that. If they want, then we'll talk about it. But do that. Most of the time, they're never gonna come back to you. But do the right thing. But as for their furniture, their big screens and this and that, throw in the garbage. Okay, they never leave the TVs or the Nintendos, but if they do, give it to your employee. It's fine. I mean, if they're not there, they're not there. Okay. But if they show up at the curb, don't let your guys be like, no, this is ours. No, they're there at the curb, place it on the curb. Don't throw it at their feet and smash it on the sidewalk. Place it down and let them take it. Okay. Nice to see you, Karen. Take care. And I know we're over the hour mark. You got stuff to do, I got stuff to do, but I will take a few more questions.
Matt, just a quick question. I had to go in and out of my office. This is Maggie with Ultimate Realty.
Hi.
I had to go in and out of my office while you were going over the ESA stuff.
Okay.
So in general, are you pretty much saying handle it case by case basis?
Yes and no. I mean, I would say that if their starting point and their only evidence is one of these certificates online or a simple statement, this is my emotional support Velociraptor. No.
Okay.
Or my emotional support, tiny little, very, very well-behaved Dachshund or poodle,
We
whatever it may be.
typically ask for not only some certificate that they can
We need
find,
we
but
need
also a doctor
doctor.
note. Yeah.
The certificate is irrelevant. These
Okay.
certificates mean nothing. I will still maintain that. From what I've read now, I believe everything revolves around actual claim of disability. That a claim of disability requires something with an MD after the name, or perhaps a professional psychologist, which is not an MD, but a PhD. So I would say you require something signed by a person with letters after their name. That is not .com. Okay. That's my thought on it.
Okay.
But again, case by case, give me a call on it.
Gotcha. Thanks.
Other questions?
Update ledgers.
Oh, ledger update. Yeah, we always say it. Sorry, Courtney is right. Please. It is such a struggle. Now, those of you on here who are good, you know who you are. Those of you who are not good, you know who you are. Just update ledgers. The requests first go out when Ginny sends the stuff to the process servers or soon thereafter. Then they go out again a few days before court. Then they go out 6 times the day before court because we're like, where's our stuff? Please, please, please. And I beg and plead of you, we are on the new system. We now have that breakdown on the ledger update page. Put in rent, look at your new ledger. When you update ledgers, just as when you send a new case, have one of these at the ready. You can get them on Amazon for like $5 each. Have it at the ready. Give me rent, late fees. Don't call it all rent. It's not all rent. Sometimes it is, but usually it's not. Go only far as back as their last payment and then itemize it down from there. Okay. Itemize it, please, on the portal. Okay. Secondarily, special instructions. Even if your company has said to us, Matt, 10 days on everything. You know who you are. A lot of people, everybody's sick of this. The rental assistants made everybody who used to be good and accommodating be like, no deals for anybody. I still please, I beg, I plead, put it on each special instructions and copy paste down the row. Okay. Or maybe you're good with a 30-day payment plan. Boom, 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 boom. I had one client who recently told me, even though they're 60-day payment plans they're good with, they want a maximum of 4 payments because I usually try to get weekly. I like people to be coming in every week. But they said to me, 60 days is fine, but a maximum of 4 payments. Okay, we'll work with it. Okay. Understand that if it's, if you say 10 days pay, that's the only deal. We also might say vacate at the end of the month, even if today's the 4th of the month. That gives them like almost the full month. Why? Because we're avoiding a trial. Because we're going to do that when we avoid a trial. Okay. It's still your best option. Trial dates are still going to be dear, especially in the county. Okay, any other questions?
If those are not updated before, then try to do it before the night of court because we make a list out of everything that we take to court. And if you guys put it on there at 10:30 when we're in court at 9 a.m., you're not going to probably get what you wanted because we don't know. So it's very important that that stuff gets updated.
Yes. So, any other questions related to anything on here? And if not, by the way, you can always call us after. You can call Courtney. I want to touch upon one more thing while I got everybody here. And I had like 47 participants today, which is fabulous. I really appreciate all of you coming. And those of you who are from big companies, you know, like somebody from Mills, somebody from Stone Creek Timberland, please, the stuff that was important, send out something. I'm going to be putting this Zoom meeting, I recorded it locally because I still can't figure out how to find it on the cloud, wherever it stores there, but I recorded it locally. I'm going to have it placed on, eventually, like I said, we're going to be having this all on the chasenet.co. But many of you have never even seen my chaselawpc.com website. Not much reason to go there. It's mostly an informational site, but we do have various videos there. This video will be on there with the title of Emotional Support Animals and whatever we're going to call this first issue of the move out stuff and that lawsuit. So I'll have that put on there here. So anybody else, they can go and grab this video and watch it. Have fun. They can bring it home and on a Saturday night, watch it with the whole family. That'd be fabulous fun. Any other question? Bueller? No? Okay, we're gonna end it here. Thank you all. As I
Wait,
said,
Matt, I'm sorry. One more thing. If you guys cannot get a hold of calling our local number, everybody should have mine or Matt's cell phone number. If we do not answer, we are in court. Text message us. We
Right.
will get back to you.
Also, if you have a question specifically on writs, those questions go to Zevi in our office. Okay, and we go from there. I got to end this because I have someplace else I've got to be. So thank you all. Have a wonderful, wonderful day and a weekend, and talk to you soon.